How does the choice of evils defense work? To find out, you have to read People versus Jimenez. It's only 8 pages. Don't have time for that? I got you covered. This is TLDR, New York Court of Appeals, episode on People versus Jimenez. This can be found at 2022 New York Slip Opinion 06541, published by the Court of Appeals on November 17th, 2022. This is a criminal case. And the issue here is the application and appropriateness of the justification charge for the choice of evils defense. It's not a very common issue that pops up. It can be found in Penal Law section 3505 sub 2. And essentially the choice of evils defense says that conduct which would otherwise be criminal is justified and therefore not criminal if it's the choice made to avoid an even greater harm. So an example of this that the decision gives says that it might be justified to burn down real property to prevent someone's real property, to prevent a raging forest fire from consuming the community. So if a fire is coming and if you burn down this one house, it will prevent the fire from consuming the rest of the community. You may be justified under Penal Law section 3505 sub 2 in making that choice between this evil and this evil. It's called the choice of evils defense. So the facts in this case are that the defendant is in a fight with a friend or a former friend, a physical fight where the defendant feels like he's being attacked and he's going to defend himself. So he takes a broom, then breaks it in half and is holding both halves of the broom and is trying to defend himself from somebody else. And a dog comes over. Gigi the dog, a small little dog that the defendant testifies he is not afraid of, and bites the defendant's pant leg. So the defendant takes his broken broom handle, and hits Gigi the dog, causing him injury, breaking the cheekbone of the dog as well, according to a forensic veterinarian. The defendant is charged before the grand jury with several crimes, including striking the dog, the crimes associated with striking an animal, criminal mischief, overdriving animals. It's not the same thing as like an assault. They don't have those kinds of terms for animal cruelty cases. And he is not given a justification charge based upon the choice of evils defense. He's indicted. He makes a motion before the trial judge to dismiss the grand jury indictment because he never got his proper justification charge as he requests. The trial judge dismisses it. The appellate division reinstates it, saying that the people didn't have to give that charge. It goes to the Court of Appeals. And they say that they reaffirm that the defendant is always entitled in the grand jury to receive the appropriate charges. The defendant, if he's being investigated by a grand jury, the prosecutor who's presenting the case has to properly charge the grand jury with exculpatory defenses that would relieve the defendant of criminal liability. Justification is one of those exculpatory defenses. So if justification was proper in this case, then the prosecutor would have been required to appropriately inform and charge the grand jury of that. But they say that the choice of evils defense has an essential element of a choice, that it has to be a conscious decision on the part of the actor to do this versus that, to actually choose to do the act. And the defendant, in testifying before the grand jury, said it was a mistake. He didn't mean to hit Gigi the dog. He was swinging the broom. He wasn't trying to hit Gigi the dog. He was trying to get away. The failure of a choice in this case, the fact that his decision to strike the dog was not actually a choice that he made, means that the choice of evils defense is not appropriate, and the people were proper to not charge the grand jury with Penal Law 3505 sub 2 justification under the choice of evils theory. If you like what you just saw and you want more of it, please hit like or subscribe to let me know.